Morning. Can you hear me?
Good morning. Yes, get a little closer, pull it down.
Microphone. All right, may it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellants, the defendants below, the Hanover Insurance Group, and Michael Arline. I'd like to reserve 5 minutes for a rebuttal, please. We're here today asking the court to reverse the final judgment that was entered in this case and to conclude that the case never should have been presented to the jury in the first place and should have been resolved either on a directed verdict or a summary judgment on various grounds.
Can I ask you a question? The way you frame your issue on appeal is that the defendants were entitled to statutory immunity and the plaintiff didn't prove the elements of a malicious prosecution. Isn't there basically turn on the same determination that there wasn't bad faith?
I think it does. I mean, I think, and I actually, as I was getting ready today, that's one of the things I think with respect to the malicious prosecution.
If we say, yeah, there's bad immunity, we're also saying we don't have the elements for malicious or vice versa.
I think that's absolutely true, Your Honor. I think, you know, when you look at claims like defamation or libel or slander, which are also sort of intended under the statute, the analysis may be a little different, but again, I think there's defamation, there's malice, they are the same sort of concepts for sure.
And, well, let me let you go for a bit first before I start.
I think I'd rather go if you want. I mean, I can.
Yeah, go ahead.
I'd rather, you want me to keep going? I'd rather answer your question.
Well, I want to just sort of clarify the sequence of events here on one aspect of this. So the accident occurs, Ms. Williams reports it to Hanover, and I guess she also talked to her insurance company, to Progressive, I believe. And then she doesn't hear anything, and she's bugging Hanover because she wants to get her car fixed. But Hanover's trying to get a hold of their insured to get their insured's version of what happened so they can make a determination on their insured's liability. And finally, I guess they get a hold of Mr. Frazier and they get his version where it's this mutual collision, and they decide, and this is what I want to clarify, and they decide at that point that it's all Ms. Williams' fault, and so they send her that letter that just really sets her rocketing off into space. With,
Right.
you know, she's very angry, which I understand her perspective on it. I'm going to be demeaning to her. So she's really angry. And in the meantime, she's calling everybody, and then what happens is they decide, and this is where I want to make sure I have the sequence right. They decide, because they're getting these conflicting versions of events, to initiate an investigation.
Well,
Is that how it gets started?
For the most part, it is, although I think the one thing is they get in touch finally, you're right, all the way up to they're waiting, they're trying to speak to Ms. Grant or Mr. Frazier. That happens in November, the accident's in October. November 5th is when they speak to him and he gives a completely different version, like completely different damages, different fault for the accident.
Right.
Okay, so when that happens, that's right, the adjuster, based on that analysis, sort of says, okay, well, it's maybe
We're going with our
50
insured.
or, right, and they send Ms. Williams a letter saying, we're looking to you to fix these damages, which she doesn't even think happened in the accident.
Right.
So then what happens is, after she gets that letter, she goes to the Department of Insurance in January and makes her own claim.
Right.
And does that tip report and tells the department that she thinks there's an issue there. She also calls Hanover and says to them, I want you to do a fraud investigation. So that's what triggers Hanover. And initially, when you read it, I don't know that they wanted to do that, but then she said to them, I have a video of him showing.
Right.
And when they saw that video, they said there is
That's
a
when they
basis for
decide
us
they're going to go ahead and do
to
it.
suspect that this is a potentially fraudulent insurance act, and they felt they had a duty then to assign it to their SIU investigator, Michael
When
Arline.
did they go from it's all her fault to it's going to be 50-50? When did that happen? Was that as a result of the investigation?
No, and I think that's a very important point, and I think throughout the case and even throughout the briefing, the plaintiff has sort of suggested that that could be evidence of why Hanover did something wrong. But what happened is that's what caused the SIU investigation to start. after they did the investigation, Hanover said, our insureds were 100% at fault. Our investigation.
Yeah, the whole 50-50 thing confuses me, and I saw something in the transcript where there's some questioning about that.
Correct.
It was in a deposition, like, well, the Hanover said, well, you know, you said she's 50% at fault, but you wanted 100% of the damages from her.
The plaintiff, in my opinion, I think that was a little bit disingenuous, or at least was confusing, and why, honestly, this never should have gone to a jury, because it created an argument that they were like taking some kind of disingenuous position, and that's just not what the facts in this case show. Once the investigation was done, that's when Hanover completely changed their position and paid Wendy Williams, saying our insured was 100% at fault for this accident. That's what it showed. And then based on that, that's what triggered the duty to advise of the results of the investigation.
Okay, so they do their investigation and resolve it in favor of Ms. Williams. And then at some point, Ms. Williams has made this complaint to the Division of Insurance.
Correct. She did it before. She
Right,
did.
and so the divisions of insurance at that point, at some point, this is where another part of the time I'm not clear about. Because of her complaint, they contact Hanover and say, we're doing an investigation, we received this consumer complaint and we need your file.
Correct. That's exactly.
And that was after Hanover had concluded its investigation?
Yes, in January is when Ms. Williams makes her complaint to DIFS, and they start their own independent investigation. In March is when Michael Arline, when they conclude, Hanover concludes its investigation and determines that there is a basis to conclude that their insureds had committed a suspected fraudulent insurance act. So they report that to the department, and in Hanover's tip report, it references Wendy Williams and says there already is a separate complaint. You should read that.
So they did report. Aren't they required by the statute?
Yes, and I think the law.
Expansive statutory and administrative scheme.
100%, Judge. I mean, in our position, that's really what's wrong here, is that the issue here is that Hanover did everything right. They did everything they were required to do in this case. They conducted their SIU investigation, and when the results of it showed that there was a reasonable belief that their insured had committed, in the words of the statute, a possible fraudulent insurance act or a suspected fraudulent insurance act, they were required to report that to the state. And that's really the problem in this case, and why we feel so strongly that this never should have gone to the jury, because the statute makes so clear that if you do what's required of you under the statute, that's why you're given immunity. That's why, whether it's an SIU or it's an individual person. Now, an individual person under the statute doesn't have the mandatory obligation.
But it also doesn't mean that you should knowingly give inaccurate information, right? The statute doesn't protect.
You can't knowingly give it.
Knowingly.
Correct,
Okay.
Judge. And
So focus for me on the typos in the tip sheets that exhibits that were shown.
right.
At what point in time did Mr. Arline become aware that the tip sheets in his left, right, and the car
Yes,
description were wrong?
I don't know that the record is totally
It's not.
clear on it. I spent a lot of.
Help me out.
Well, I spent a lot of time when I wrote my reply brief, because obviously it's very important. I think it's very clear that as of the time after the prosecution was already taking place and Mr. Arline was deposed in the criminal case, he was still making the same mistake. And I think the important thing is,
And he didn't testify at the criminal trial,
he did not.
so that wasn't a fact that came out as far as the typos.
It wasn't. And I think another important thing to keep in mind is that Tom Everhart, the investigator at the Department of Insurance, that he didn't even know about it. He said he didn't even find out about it until during the criminal case. So he had already been prosecuted.
Let me ask you a question then. So hypothetically, if Mr. Arline had become aware that the information was false on the tip report and just didn't tell anybody by his omission, and he continued to go forward, would he be entitled to the immunity under the statute?
I think you would, because I think the way it should be interpreted, and granted, no Florida case has
Okay.
really interpreted this
But if
yet.
he's continuing to, like, if law enforcement is soliciting affidavits and he knows it's wrong and he's not correcting it because his prior report says so.
But again, Judge, I think there's two comments to that. One is, it is not, the mistake that he made it was literally just mixing up the left and the right side. This wasn't like he was saying, oh, I was wrong, the damage really did happen and I was wrong. I mean, the situation in this case and what the Fraudulent Insurance Act was that the insureds were not being truthful about having any damage to the passenger side of the car. So again, the left, right, it really is a red herring. And I would agree that if he said, you know what, that damage really did occur in this accident, I was wrong about that. That's a different story than the left, right. I mean, it didn't really matter. Again, those aren't even the facts because I don't think there's any evidence he knew about it till much after. So I don't think that matters here. But even looking at it in this case, it has to be, and in this Zellmeyer case, which is the New York case that I think has interpreted the very similar language, they really said it has to be intentionally knowing wrongful conduct in filing the report. Basically doing something you know is wrong to get someone prosecuted. And Judge Kelly, I think that goes back to what you're saying. It sort of ties into, that would be a malicious prosecution came with you. You're doing it wrongfully, there'd be malice, that's just under no reasonable interpretation of the facts in this case, anywhere close to what happened here. And we really would ask the court to recognize that Hanover did and Michael Arline, they did everything that they were required to do under the statute. All they did, they made the report and then they were asked for information and they provided it, and that's it. And I think when you read the cases that have interpreted sort of the out-of-state cases where they've said someone may not be entitled to immunity, and even in Florida, that Horning-Keating case that plaintiff actually cited in their answer brief, I think that case is a great example of going beyond what's required when an adjuster or anyone who makes a report sort of injects themselves into the investigation and sort of does things and brings witnesses and talks to the, whether it's a prosecutor or an administrative agency. That's sort of going beyond, but there's nothing in this case. They did nothing like that. And for that reason, again, we feel strongly that this is a case that should have been resolved on summary judgment based on a finding that Hanover and Michael Arline were entitled to immunity and couldn't prove the elements of malicious prosecution. If the court, I'll reserve the rest of my time for rebuttal.
Very good.
Melissa Bach from the law firm of Bradlock, Alvarez, Jones, Russo, and Guyton on behalf of Luke Frazier.
You really need to speak up as well, or pull out the
Is that better?
That's here.
A little better? I'll try to speak up, Your Honor. Your Honor, this is a highly specific, or rather fact-specific case, and clearly that was touched on during the course of the initial presentation. The events which formed the foundation of the malicious prosecution claim occurred in 2010. Luke Frazier was operating a vehicle that was owned by Mayor Vic Grant when he was involved in a motor vehicle accident with Wendy Williams. The vehicle driven by my client was insured by Hanover, as we have discussed. Unsurprisingly, both Williams and Frazier disputed how the accident occurred. A claims adjuster for Hanover determined that both Williams and Frazier were 50-50% at fault for the accident. Williams later produced a video which did not show the actual accident, but a brief interaction between some of the drivers. Because Williams was so strenuously demanding an investigation
Do we need to get caught up, and I know you're telling the details of the factual scenario, but do we need to get caught up in the liability of the accident?
Your Honor, I think that is
Purposes of what
important.
we're deciding today.
I think that is important, Your Honor, based on the stance that Arline and Hanover took once the criminal prosecution began with regard to the liability. So I do think that is
But
important.
Arline didn't even testify in the criminal trial, is that right?
That is correct, Your Honor. Arline did not testify at the trial. However, he was subpoenaed for deposition. He was subpoenaed for trial as well. And during the course of the criminal investigation leading to the prosecution, or as part of the prosecution.
Well, you know, I'm gonna try to cut to the chase here, because I have to, you know, be candid with you, I'm scratching my head on how this case made it, as far as it did, to be honest with you. Please give me your best argument on how there's any bad faith here, anything that meets the standard that would either preclude the immunity from being applicable, or that would support a claim for malicious prosecution. I really want you to drill down on what you think factually is your best case for that.
During the course of the investigation by the fraud department, Arline was contacted and they requested they forward his file. Not only did he provide a tip report, which had multiple clearly erroneous entries, but also
Exactly, clearly erroneous, because in the context of everything else, it was pretty apparent that the problem was, Ms. Williams said there was damage to one area of Hanover's insured's car, and the insured was saying there's damage to two areas. So, you know, so what? Like, everybody knew. Williams had given statements, there was a video recording, like, so what? That it said left. When you read this transcript, throughout this transcript, the lawyers, the witnesses, everybody confuses left and right. It happens repeatedly. So, I'm lost on why that's significant.
Your Honor, it's not only the tip report that contained that supposed typographical error. As conceded at page 18 of the initial brief, the SIU report contained multiple misstatements of the fact as well.
What are those multiple misstatements?
They also, once again, refer to the damage being on the wrong side of the vehicle. Also,
Well,
Michael Arline.
The question is, was it one area damaged or two?
There was damage to only one side of the vehicle, which the parties agreed was caused by the accident.
Right.
However, during the course of his investigation, Arline did not only limit his statements with regard to whether it was on the left or the right, he also made multiple statements with regard to Grant confessing that they had perpetrated fraud, and that simply wasn't the case. She used the phrase, "I'm sorry," at some point, and he conceded that that was not necessarily a confession, but the word confession does appear in the SIU reports and the tip reports repeatedly. So it is not simply...
Ultimately reports damage to both sides of his vehicle, right?
He reported damage to both sides of Grant's vehicle based on the way he experienced the accident and the way that he
The
recalled
vehicle
it
he's
occurred.
driving or he's in.
Correct.
Okay. And ultimately, the conclusion was that as a result of the accident, there was only damage to one side.
That is what everybody agreed on, that there was definitely damage to one side. It was his position that there was actually damage to both.
So it seems to me that much of your position is based on an inference that this must be malice because of the error in the reporting. So when is it enough to go to the jury as opposed to evidence of some bad motivation that then supports a claim of malice?
Because, Your Honor, the issue is not simply the tip report. The issue is not that he prepared a tip report that used the word left versus right and that he submitted simply something that said left versus right. The tip report specifically referred to a confession supposedly made by Grant that there was no recording of, and that he later admitted.
That's an interpretation of the various circumstances, correct?
That would be, yes, Your Honor.
So why would that not, in good faith, be enough to say, we think there's a claim that's been artificially increased for more coverage or more, based on more damage? And why is that not enough to warrant an investigation? See, is it an artificial increase in the claim?
Your Honor, the fact that an investigation took place in and of itself is not the problem. The statute also references furnishing other information without malice. There would be immunity if there was a submission of a report
No, so
or
that
other
goes back to my earlier
information.
question. what's the evidence of malice or bad faith?
In
Is
this
it
circumstance,
Go ahead.
okay, in this circumstance, clearly there are errors in the tip report. The issue is not simply whether or not the tip report was submitted and there were errors therein. The issue is that having become aware that those errors were being used in the criminal prosecution, both Arline and Hanover took absolutely no affirmative steps
I
to
thought we
correct
said the
that.
record wasn't clear on whether he was aware of that or not.
I did not say that, Your Honor. I believe counsel made
Yeah.
that argument. Certainly by the time he was
What in the
deposed,
record demonstrates that he was aware that that was, I mean, to me, it's such an obvious error, like, why would you, I mean, if he was aware of it, wouldn't, I would assume anyone that looked at all of this material would be aware of it.
Your Honor, I would agree that Michael Arline, certainly by the time he was deposed, was aware that an error had been
Which
made
deposition? The criminal or the civil?
during the criminal deposition, Your Honor.
Okay.
Because he was called to testify during a criminal deposition. He did not testify
And
at
it
the
was
trial.
pointed out in his deposition that it was, he meant left and not right.
The,
And he says it's a typo.
he did characterize it as a typo. However, this is a typo that was manually entered multiple times. And again, he made no attempts once he realized
But
that
he
error
entered
to
those
correct
multiple
that.
times before the deposition that said, this is wrong, isn't it?
By that point, certainly he should have realized, but again, he did not take the position that, dear God, I'm so sorry, this is clearly an error, and I have
Well, let me ask
submitted.
you, if he had, then wouldn't it make it worse? I mean, how does that help anything?
Michael Arlen Hanover had multiple operations
No,
to
but how
contact.
does that, I don't understand how that improves the situation for, Mr. Frazier. If he says, oh yeah, I meant right, because then it's, because, and I think there's something in one of the reports where he talks about, I was a highway trooper in Georgia or an accident investigator, and this damage, this other damage clearly wasn't in a moving situation, something to that effect.
Your Honor,
Is that
ultimately,
in the same report?
that is in the report that was prepared by Eberhardt. He was the investigator for the Division of Insurance.
That's Everhart?
I believe so, Your Honor.
I thought Arnold testified he was a licensed private investigator in Georgia. Maybe that's what it was. Okay, well, anyway, that's in there somewhere. I mean, all that's available. Ms. Williams' statement's available. So I really want to give you your best shot at telling me why it makes any difference whether he said left or right, used the word confess, admitted. I mean,
Michael Arline, as an employee of Hanover, submitted documents that contained what were clearly either misrepresentations or gross errors.
okay,
Have you had an
there's
opportunity?
clearly an error in it, clearly, but you gotta, like, you need more than that.
Your Honor, during the course of
Like,
the
he's out to get Mr. Frazier.
well, during the course of the criminal prosecution, certainly neither Mr. Arline nor Hanover contacted the Department of Insurance and said, we have a problem. Our SIU report, our TIPS report, all of this information that we have in our
How would
file
that have
is
changed anything?
because
It,
That
when
was
I
part-
said left, I meant right. How would that have changed anything?
they certainly relied, at least partially, on the documents that were provided by Hanover in
Okay,
continuing the
question was,
prosecution.
how would have said, saying right instead of left? Let's say you told everybody in the world, oh gosh, I just realized, when I said left, I meant right. How would that have changed anything?
Because the criminal prosecution was at least founded in part on Hanover's documents, Hanover retracting those statements or Arline retracting those statements.
But I
But it
think
should have
the criminality, the alleged fraud was reporting 2 areas of damage as opposed to 1, correct?
We are not conceding in any capacity that,
Okay, then what was the alleged fraud?
are you asking whether
What
alleged
was the-
fraud
I'm
was?
asking you, what was the fraud that was alleged?
Hanover alleged that,
No, the state. What fraud did the state allege?
he was prosecuted for making a false statement in the reporting of an insurance claim.
And what was the false statement?
The false statement would have been that there was multiple areas of damage.
Okay.
Okay, let me go back to the deposition because I think I didn't realize before that as far as this typo, how this implicates the rest of the malice issue. So if you're telling me in the deposition, it's disclosed and he admits that it's a typo, doesn't everybody read the deposition to know what the deposition reads and that it's a typo, and going forward, everybody knows it's a typo, so what is the point?
The point is neither Hanover nor Arline ever took any affirmative steps to either withdraw from their prior
Okay,
position.
So let me point you to the case of the Berger v. Time. I think this is cited by Hanover. This was the 11th Circuit. I realize it's federal, but it applies our law. And it says that prosecution does not lie where a defendant merely gives a statement to the proper authorities, leaving the decision to prosecute entirely to them. But then it also goes on to say, here, in this case, I guess, although Berger claims that Time failed to disclose exculpatory facts, Berger has not shown that Time did so with malicious intent. Don't we have the same scenario here, where you're arguing that Arline failed to disclose, Hanover failed to fix all these problems, yet you still have to show malice?
Your Honor, it is certainly our position that, again, not retracting the statements and continuing to support their position that fraudulent statements had been made.
Well,
Notably,
you know, and sorry to interrupt, but what you just read also, I think was a much more articulate way to make the point I'm trying to make. What was exculpatory? Nothing exculpatory was withheld.
Your Honor, the Department of Insurance
Or
was,
was it? I mean, is it your position that saying it was the right side instead of the left was exculpatory?
exculpatory is not the word that I would use, Your Honor. The issue here, of course, is that there was a failure to disclose with regard to the initial evaluation of it being a 50-50 accident. There was a failure to actively,
A failure, wait, the initial what?
the initial determination that it was an accident that resulted in as a result of 50-50 liability, as initially determined by the adjuster that
I
handled the
think
case when it
everybody
came
was
in.
aware of that. Because that's how this whole ball got rolling. And so what? Because that was based on Mr. Frazier's statement, right?
That was based on statements by all of the parties involved at that time, Ms. Williams and Mr. Frazier.
So apart from this question of malice and bad faith, was there any evidence to suggest that the criminal prosecution would not have been initiated based on the investigation that the department conducted, but for the mistake or the misidentification of which side of the car was damaged?
There was a tip report that was filed by Ms. Williams prior to the tip report that was filed by Hanover. However, it was not until they received Hanover's file and conducted their investigation based on, at least in part of the materials that they received from Hanover, that the criminal prosecution was commenced. So certainly would be our position that it was Hanover's tip report, SIU forms, and claim file that led to the criminal prosecution of Luke Frazier.
Is there any evidence, apart from your argument, is there any evidence that the department lacked a basis to investigate, but for that statement in the Arline report and the related documentation?
Your Honor, in light of the fact that the state relied on Hanover and Arline's documentation to commence I'm not sure that I'm following the question. Let me stop my rambling and ask that you
The
repeat
point
the
that I'm
question.
making is there any evidence that the department would not have proceeded further had they understood there was no damage, there was no damage as a result of the accident to the right side, the passenger side, and there was an error in the reporting documentation? I mean, it seems to me, to go back, I think it was Judge Kelly's question, how does it matter? Don't you have to show that this prosecution only occurred because of the error in the reporting?
And certainly it is our position that this prosecution occurred only because of the errors.
I
in
understand
the
that's your
reporting.
position, so what's the evidence? Did the department get deposed and say that that was the controlling factor? I
There
think
was
the answer
not
to
a
that is no.
there was not a specific agent appearing on behalf of the department that made that statement. No,
And
Your
so
Honor.
the department had conducted their own independent investigation, and they concluded that there was fraud. Fraud in the representation of where the damage occurred, not a misleading as a result of the Hanover reporting documentation?
What is the question, Your Honor?
Tell me what evidence establishes that this investigation and the resulting prosecution would not have occurred but for the Hanover information.
It was Hanover's claim file in which they relied. They deposed Arline. They did not depose Mr. Frazier. It was based on those documents that the prosecution was commenced.
Your client had the ability to depose whoever he wanted, right?
Yes, Your Honor.
Did he gather any evidence that supports the argument that this investigation would have stopped dead in its tracks once this reporting error would have been corrected?
Neither side asked that question specifically of.
So the answer is there's no evidence that this investigation was solely as a result of this error in the reporting.
Solely, no, Your Honor. It would have been at least partially as a result of the investigation done by
And
Hanover.
the department completed its investigation,
It did.
and the department concluded that Mr. Frazier lied.
The department concluded there was enough information or evidence to proceed with the prosecution.
You've got 2 minutes left.
Okay, Your Honor, I appreciate that. In asserting that Hanover and Arline are immune from suit, in this particular case, Hanover and Arline cite a few out-of-state cases, but only one Florida case, and I do want to focus on that for just a minute. That particular case is Sands v. State Farm, which is a 2003 case out of the 3rd District. I focus on that because, again, it is the only Florida state that they relied on this particular point of law in their initial brief. What was interesting about that particular case is that a State Farm insurer specifically submitted a claim for living costs or living damages following a hurricane. State Farm determined that that was fraudulent and submitted a report to the state. The state determined there was probable cause to prosecute, but ultimately ended up dropping any charges. In that particular situation, the department was actually able to corroborate everything that was in State Farm's report. They simply decided not to prosecute. Because of that, the 3rd District did affirm the summary judgment, again, affirm the summary judgment for which State Farm moved. That is not the case here. Here, the documentation that was provided to the state by Hanover and Arline was replete with errors or misrepresentations or mischaracterizations, depending on your point of view, clearly. So none of the factors that are relevant in Sands, which is that, again, the state was able to corroborate everything that State Farm submitted, is available here. The state did not confirm what was in Hanover's file because, again, it was complete and replete with misstatements, mischaracterizations regarding confessions that did not occur, or, again, this issue with regard to left and right. The jury was provided plenty of evidence from which they could infer that bad faith had occurred. The trial took the course over multiple days. It was a 4-hour deliberation. There were questions presented by the jury. They actually got instructions requested by the appellants with regard to the filing of reports, and nevertheless still determined that Hanover and Arline acted in bad faith in continuing the prosecution against my client.
End of your time.
Thank you. And that was my final point, Your Honor. Thank you.
Very good. Thank you very much.
I don't think I have a whole lot to offer here. I mean, I did want to just point out, Judge Kelly, I know you were asking about the distinction between whether it was Arline or Everhart, and actually it was both of them. And Michael Arline was a Georgia officer. You were right about that. But they both actually testified as part of their investigation to going up to the scene to saying, could this damage have happened the way he said? And both of them came to the conclusion it absolutely could not have. Also, another point, I mean, I think it's very clear that Tom Everhart was emphatic during his testimony that nothing Hanover, Michael Arline, the left, right, none of it had anything to do with his investigation. And that's the way the statute is intended to work. And I really think that's the important part of this, is that the way this works is that the insurance company is tasked with determining, is there a possibility that a fraudulent insurance act was committed? If it was, it's expected and mandated to report it. And then it becomes the department's duty and obligation to do an independent investigation. That's exactly what was done here. So at the end of the day, we believe this is a very, very important case for the court to address. And that if it's not reversed, it really is going to have an effect on the way the states fight against insurance fraud, because insurance companies, I'm sure Hanover's not going to be real willing to report things if this decision is affirmed. And, you know, it's an important case, and we'd ask the court to reverse and remand for entry of judgment in favor of Hanover and Michael Arline on grounds of immunity. Thanks.
Very good, thank you both. That concludes this session of our oral argument docket. We are adjourned.
All rise.